Goedemorgen, dames en heren.
Good morning, ladies and gentlemen.
Op 9 maart
On the 9th of March 2020,
is de zaak
the
MH17
MH17 case was initiated,
en op 23
and on the
maart
23rd of March,
is het onderzoek
the court
bij de
hearing
rechtszitting geschorst
was
tot
suspended
vandaag.
until today.
De rechtbank zit weer
The
in
court
dezelfde
is sitting again in the same
samenstelling
composition
waarbij het onderzoek
and
werd
hereby
gestart.
resumes the trial.
Aanwezig zijn
Present
in de zaal mevrouw
in the
de
room
Straat en de heer Van
are
Eyck,
Ms.
de raadsleden
Duskata and Mr. Van Eyck, counsel for Mr. Pulatov.
verder namens het rechtsbijstand
Further, there's a counsel for the
mevrouw
relations,
Schijns en de heer Pijnenburg.
Ms. Skydens and Mr.
Verder
Pijlenburg.
van justitie
We have a public prosecutor
en een aantal
and a
nabestaanden
number of
en
relatives and
vertegenwoordigers
representatives
van
of the press.
Welkom allemaal.
Welcome, everybody.
Voor de goede orde merk
For
ik
the
op,
avoidance of doubt, I
deze
would
zaak
point
de
out that
volgende
today's case has
verdachten.
the following
Dat is
suspects.
ten eerste de heer
Firstly,
Pulatov.
Mr. Pulatov.
De heer Pulatov is niet verschenen.
Mr. Pulatov is
Wel
not
zijn
here.
aanwezig zijn raadsleden,
He is represented
zowel mevrouw ten Doesgaat en
by
de
his
heer
counsel,
Van Eyck.
Ms. Danduskata and
U was
Mr.
ook
Van Eyck.
aanwezig bij de
He
eerdere
was also not present at
zittingsdagen.
the previous
De
hearings.
cliënt was op die
Your
dagen
client
ook niet aanwezig.
was also
U
not
was
present
uitdrukkelijk
on that
gemachtigd
day,
om
and
hem
you were explicitly
te
authorized to
vertreten.
represent him at the trial.
En ik vraag u ook
I
vandaag
ask you whether you
uitdrukkelijk
are
gemachtigd bent.
explicitly authorized today.
Dank u wel.
Reply yes. Thank you.
En verder betreft deze zaak
The further
verdachten
suspects in today's case are Djerkin,
Dubinsky
Dubinsky,
en Tjatchenko.
and Karchenko.
En deze drie verdachten zijn
These three
wel
suspects
verschenen.
have also not appeared today,
En dat
and that
was ook
was
het
also the
geval
case
bij de vorige
at the previous
zittingsdagen.
hearings.
De rechtbank heeft toen
The court
vastgesteld
decided at that
dat
point
zij op rechtsgeldig
that they
bewijs
had
waren
been
opgeroepen.
summoned to the hearings in accordance with the law.
Daarom heeft
For
de
that
rechtbank
reason,
verstek
the court
verleend
decided to
en
proceed,
zijn hun zaken
in the
buiten
absence,
aanwezigheid van deze verdachten.
and the trial continued in absentia.
Die oproeping,
The summons,
de rechtbank eerder
which
als
the court had
rechtsgeldig
deemed to be
aangemerkt,
legally valid,
betrof niet
concerned
alleen
not
de
only
aanvang van
the
de zitting
initial
op 9 maart
sitting on the
2020,
9th of March 2020, but was
maar
also a
tevens de
summons
oproeping voor de eerste
for
zittingsdagen
the first hearing
van
days
reeds geplande
for all the
zittingsperiode.
other scheduled hearing
Waaronder het
blocks,
zittingsblok dat
including
vandaag
the block of hearings which begins today, 8th of June 2020.
En dat betekent
That means,
dat de
therefore,
zaken tegen
that the
deze drie verdachten
cases against these three suspects are continuing today in absentia.
Er is dus, net als bij de vorige zitting,
Just as in the
sprake
previous hearing,
van een
therefore,
gelijktijdige, maar niet
we have a
gevoegde
simultaneous
behandeling
but not
van
joined
deze
treatment
strafzaak
of this
tegen 4 verdachten.
criminal trial of 4 suspects.
En dat betekent dat
That
alles
means
dat
that
op deze zitting
everything
aan de orde komt,
that is discussed
in
at
alle
today's
zaken
hearing
wordt gezegd.
applies to all 4
Tenzij
cases
dat
unless
het
it is
precies
explicitly
anders wordt
stated
aangegeven,
otherwise,
of
or if it is
wanneer
clear
duidelijk is dat iets alleen
that something only
één zaak
concerns
aan de orde
one
is.
case.
Bijvoorbeeld
For example,
de dingen die door de
things
verdediging
which
van
are
verdachte
said
Pulatov
by the
worden
defense
aangevoerd.
of suspect Pulatov.
Deze zitting vindt vandaag
Today's
plaats
hearing
met enige beperkingen.
is subject to a number of
Die
restrictions
voortduren uit
because
maatregelen
of
ter
the
voorkoming van
measures
de
taken to
verspreiding van
prevent
het
the spread of the coronavirus.
In deze zittingszaal zijn
The courtroom
voorzieningen
has
aangebracht,
been
zoals
adapted in a number of ways. For
schermen
example, you can
zijn
see
gemonteerd.
screens that have been installed.
Verder,
In addition,
aantal aanwezige
the number of
personen
persons
is
present is restricted
maximaal
to
30
30.
per locatie. En dat betekent
That
dat
means
deze zittingszaal
that today's courtroom
in de zaal en
only contains
slechts een beperkt aantal
a restricted number of lawyers, relatives, and representatives of the press.
Dat geldt ook
The same applies to the press center. There again, only 30 people can be present.
kan de zitting.
People in the press center can follow the proceedings on screen.
De zitting is
Today's hearing can also be heard
via de internet
via live stream on the website www.courtmh17.com.
En deze
The live stream can be followed in Dutch and
Engels
English.
worden gevolgd. En via de livestream
The live stream always shows an image from one of the cameras in the courtroom. Which image is shown
Dat wordt dan
is decided by the court technician in accordance with the press guidelines.
Het is om
For privacy reasons,
niet toegestaan beeld en of
photographs and sound recordings are not permitted
Dat geldt eveneens voor
during
beeld
the
in het perscentrum.
hearing, and the same applies to the images shown in the press center.
Bij een onderbreking van de zitting
Whenever the hearing is adjourned,
gezegd op welk
you will always be informed at what time it will be resumed.
En zodra de zitting
And as soon as there is an adjournment, the live stream is stopped for the duration.
van de beelden in het perscentrum
The images will cease to be shown on the press center once everyone has left the courtroom.
voor de goede orde merk ik nog op dat
As a point of information, I'd also point out that at 12 o'clock today,
NL alert
the NL alert system will be activated.
mobiele telefoon bij u mochten hebben die
That means that if you have a mobile phone with you, we hope it will be switched off,
wel ja, dat we dan dat geluid zullen horen.
but we will hear the sound of the NL alert system at noon, just to inform you that that may be happening.
Van hetgeen tijdens de vorige zittingsdagen
Now, regarding the previous sessions on the 9th, 10th and 23rd of March, the events have been duly recorded. In the record, you could see that the criminal case was initiated on the 9th of March 2020, the case was presented, and that the prosecution service, the defense, and the counsel for the relatives
bijstandsteam MH17 van de nabestaanden
were all able to make initial statements. Furthermore, the preceding investigation was discussed, and applications from the prosecution and requests from the counsel for the relatives were discussed. On the 23rd of March 2020, the court referred the case to an investigating judge in order to make decisions on defense's request for translation of documents and request from the public prosecutor to grant leave to withhold defense access to a number of documents that were not in file. In addition, the court instructed the public prosecutor to produce a transcript of identified documents and to make them available to the counsel for the relatives, and the court imposed conditions for the use of these documents. The public prosecution has carried these instructions out. The court decided at that time that no deadline would be set for the defense to speak before today's hearing at 2020 and to express any request for investigation or request to interview suspect Bulatov or challenge any telecom interceptions. The court also decided in response to applications from the prosecution that the defense would be able to respond duly to these on today's hearing, 8th of June and following. Regarding the prosecution's request to hold the hearing at another location in order to view a reconstruction of part of the aircraft, the court has invited the prosecution to provide further reasons for this request and to inform us how such a viewing could actually take place. The court drew a number of further points to the attention of the prosecution and the counsel for the relatives. The public prosecution has sent us its response in writing, and the counsel for the relatives has informed us that they will be able to respond to the questions in early September 2020. At the previous hearing, the court also decided, again, after discussing with defense and prosecution, the decision was that today's block of hearings would be the opportunity for defense to raise some preliminary objections, and they would be able to make further requests for additional information, additional investigation in the course of this block of hearings. On the 23rd of March 2020, the court invited prosecution and defense to get together and discuss the possibility of a stepwise treatment of the file and to inform the court of its views on the matter prior to today's hearing. Defense informed the court by letter of the 24th of April 2020 regarding the process of its work. Here they indicated that the restrictions because of the coronavirus were making it difficult for them to get in touch with suspect Bulatov. In addition, defense said that the same restrictions meant that they were not able to consult a number of advisors as they wished. They therefore expressed misgivings regarding its ability to prepare and pursue these consultations. The prosecution responded to this in a letter of the 1st of May 2020 and briefly adopted the position that there was no reason to change the schedule of hearings already established because by the 8th of June 2020 the defense would have had satisfactory time and opportunity to make requests for investigation, to prepare its preliminary objections, and to prepare its response to a number of applications from the prosecution. Here, the prosecution also pointed out that requests for investigation could also be submitted at a later stage if they cannot be done early. Defense responded to this in a letter of the 8th of May 2020 And the court then responded in a letter of the 12th of May 2020, addressed to defense and prosecution with a copy to the counsel for the relatives, as follows. The defense will be invited to submit preliminary objections on the 8th of June 2020. These objections are largely technical and legal in nature and can therefore be discussed without investigating the case proper. The court takes a view that this is a possibility for defense despite the restrictions we mentioned earlier. The defense does not need to submit all its requests for investigation at today's hearing. But if requests are submitted at a later stage, defense will have to indicate why they could not be submitted earlier. The court expects that defense will respond to any applications from the public prosecution as much as possible, if it has not already done so. And where it does not do so, the court will expect explanation of why it was not possible to do so. The prosecution will get the opportunity, during these June hearings, to give a presentation of the various investigations which have been carried out at various stages by the various investigative authorities and others. Here, they will be able to tell us what intermediate conclusions the investigators and prosecution have drawn, in order to give us a full view of why it has been decided to proceed with further investigations on some fields and not others. This hearing is still at the pre-trial stage, and it is therefore not the intention that we should be given full detail of all the thinking behind the intermediate conclusions and a full presentation of everything contained in the reports, the interviews, and other official actions. The purpose of the presentation is essentially to give the defense the insight it wishes into the various investigative actions and the structure of the file. In a letter of the 29th of May 2020, the court drew prosecution's attention once again to the point that the purpose of the presentation is to give an overview of the investigation and its structure, in order to reply to the question of whether the investigation has been completed. The public prosecution will therefore giving us their view at a later stage at this hearing, and they'll be telling us about the investigation and what the public prosecution has already done so far. Finally, the court proposed that there should be discussion with defense and prosecution to decide in what way the file should be discussed in substance at this trial. A point of information here, for any who are not familiar with the matter, in a Dutch criminal trial, it is normal for the written file to be discussed in court in the presence of the suspect. The suspect is then taken through the file and questioned on it. And during these discussions is when everyone present and the general public gets a clear view of what is on file. If no suspects are present, or if a trial is taking place in absentia, then there is no one to question. In these cases, it is not unusual for the substance of the file to be dealt with only briefly and summarily. In this case, the court, however, takes a view that that is not appropriate and not advisable, because this is an unusual case and has attracted great public attention in the Netherlands and beyond. The way in which the substance of the case can best be discussed is a matter of organization of the hearing, and therefore does not need to be discussed at the hearing itself. So after this letter from the court, defense and prosecution undertook further talks together, and they informed the court of them on letters of the 27th and 28th of May. The counsel for the relatives also informed the court that it does not essentially wish to speak at today's hearing, except on issues that may arise for response. The counsel for the relatives has made a number of requests in writing, and I'll come on to those in a moment. In the light of the above, the Court has the following main items on the agenda for the period of hearings. Firstly, the Court will open the hearing and we will get a presentation of the current situation. Then, defence will have the opportunity to speak. After that, there will be a presentation of the preliminary investigation made by the prosecution and applications for further investigation. After this presentation by the prosecution, the hearing will be adjourned to give defence an opportunity to make a response to what the prosecution has said, in order to produce any possible requests for investigation or for any other point which the defence may wish to discuss. After this, the prosecution will respond, probably after a further break, so that they can prepare their response. After that, defence will be given the opportunity to speak again. After that, the hearing will be suspended again, in order to give the Court the opportunity to deliberate on all the information, requests and applications, and make decisions accordingly. It is expected that defence will be taking the floor in a moment, and after that, the prosecution will start its presentation of the preliminary investigation. This presentation will last several days. After that, the Court, if it sees fit, will then speak again. After that, the hearings will be suspended, probably until Monday, the 22nd of June, and will probably continue for several days that week. The 22nd of June, I say, will be decided in due course whether we do in fact proceed on that day as planned. Any further decisions from the Court regarding the coming weeks will be communicated to you on the 3rd of July 2020. Now something regarding the file. Some additions have been made to the file since the previous hearing. The Court now wishes to find out whether it currently has access to all files and whether defence has also received them. There's a number of additions that have been made, including addition matters regarding investigative powers, images relevant to parts of the file. This is a number of images and videos based on records of underlying files, in particular identified parts of the investigation and named sources. In addition, additional points made to the personal files of the four suspects, witness statements, including some of those who had already been heard by the investigating judge but could not be added to the file earlier, further investigation of presumed satellite images, a number of digital documents regarding missile management, investigation results regarding the Russian language discussion forum GLAV, a file with a number of photos from open sources showing the disaster area, the recovery and repatriation of mortal remains, the transfer of the recorders, and the recovery and transport of wreckage. In addition, further investigation of telecoms and investigation of radar images. In addition, a number of additions have been made. These are minor corrections and some annexes which could not be put on file at an earlier stage. The Court will add these files to the files of all suspects, so that all suspects have the same matters on file. I'll now talk about the appeal regarding the status of threatened witness. The prosecution asked the investigating judge to grant 13 witnesses in the course of the investigation the status of threatened witness, and the investigating judge did so. In two cases, this took place at a stage of the investigation regarding an unknown suspect. This is known an application regarding persons unknown. That can be done if witnesses need to be protected, while no suspect has yet been identified. If a suspect has been identified, then the application names the suspect, and the suspect must be given the opportunity to speak regarding the application. In this case, the witnesses are X48 and V11. The investigating judge has heard both witnesses, and the record of the interviews was then provided to the prosecution, who added it to the file. In the other 11 cases, the applications name the suspects, in the cases against all four suspects. In all cases, the investigating judge also heard the relevant witnesses concerned. Because the suspects were not yet aware that the status of threatened witness had been granted, and the prosecution had requested that suspects should not be informed of it at that stage of the investigation, the investigating judge heard these witnesses, but the records of the interviews were not added to the file at that stage. Suspect Pulatov's defense early this year, when the suspect was informed of the judge's decision to grant this status, the defense lodged an appeal against the judge's decisions. The defense concerned all 13 of the investigating judge's decisions. The other 3 suspects have not lodged an appeal against the investigating judge's decision. Now, the appeal was lodged at the court in The Hague, and the counsel of the court, with different judges from those today, because we are actually discussing the substance of the case, the court discussed this appeal in chambers in early April. In the case of witness V11, it was decided in council that Mr. Pulatov had already been identified as a suspect for a long time before the prosecution made its request to the judge, who then made his decision on the 5th of July 2018. This is because there was a record of suspicions against him dated 25th of October 2016. Since, however, the application from the prosecution was made against persons unknown and not in his name, Pulatov was denied the opportunity to speak before the investigating judge made his decision. That is an omission which can no longer be remedied. Now that the record of V11's interview has already been made available to the prosecution by the investigating judge, and the prosecution has added it to the file, Mr. Pulatov's appeal, therefore, is justified regarding this witness, and the decision of the investigating judge to grant threatened witness status to V11 is therefore reversed. Normally speaking, in a case like this, the investigating judge would have to destroy the relevant statement. However, the record of V11's statement is already in the prosecution file, and so we'll then have to discuss what that actually means. Regarding the other witness, X48, the decision in council was different, because Pulatov was not identified as a witness when the prosecution made its application and the judge made his decision on the 15th of January 2016. It was therefore decided in council that the investigating judge's decision in the Pulatov case was justified regarding that witness. The court further decided regarding the appeal in council that the investigating judge had been able to make a reasonable decision to grant the other witnesses the status of threatened witness. To that extent, Mr. Pulatov's appeal was dismissed. As a result of that, the investigating judge has made the record of the interviews of the other 11 witnesses available to the prosecution. These records were then added to the file of all 4 suspects. Now, correspondence from the Council for the Relatives. The court has received a request from the Council for the Relatives to determine that the Counsel for the Relatives will be informed of any requests from the prosecution or defense or the investigating judge during the investigating judge's initial investigations. The prosecution gave a written reaction the 12th of May 2020 saying they saw no legal basis for this and takes the view that the Counsel for the Relatives should address requests for information to prosecution even after the trial has begun. It is a matter for the prosecution to decide and remains so even after the hearings have begun, according to the prosecution. On the 20th of May this year, further discussions on this matter took place between the prosecution and the Counsel for the Relatives, and the outcome of this discussions have not yet made available to the case, but I dare say we will hear them in due course. Further, the court has received a further request from Mr. Spett and Mr. Collignon regarding an increase in the number of relatives who can be represented by Counsel for the Relatives. Now a number of questions which the court received, a number of questions the court posed on the 23rd of March and replied to by prosecution. The first is a letter of request to the United States regarding PIN and credit card details of the supermarket and a number of other identified companies in Snizhne and on the road from Donetsk to Snizhne on the 17th of July 2014. The prosecution responded that it has received data, but they are not relevant, as it turns out, and they do not contain any indications for further investigation. The court also understands that the prosecution, therefore, will not request that this data should be added to the file. Secondly, the court asked whether consideration is being given to classified satellite images which appear to show a missile being launched and which have been shared with the Dutch secret services should be added to the file via declassification. The public prosecution responded that a request was sent to the American authorities in 2014, and in response to it, a memorandum was received from them. A Dutch national anti-terrorism prosecutor was given the opportunity to check whether the memorandum was correct. For that reason, the classified information was made available to him in a confidential manner, and the public prosecutor came to the conclusion that the memorandum is supported by the other sources he consulted. They also indicate that his statement has been put into the file with a second edition. The American authorities informed us that they cannot provide any additional information regarding the launch of the missile that is stated in the memorandum and that has already been made available to the anti-terrorism prosecutor in a confidential manner. That was the reply from the prosecution regarding the court's question, and the court understands from this that no further information is to be added to the file as a result. The third question from the court was whether additional possible victims have been approached in order to see whether compensation could be made to the relatives of the people aboard the aircraft. Here, the prosecution indicated that a number of actions had been undertaken, but they had received no response. Malaysian Airlines has been asked several times, and several times, most recently this year, said that it does not wish to play any part in the criminal trial. So the questions put forward by the court on the 23rd of March are to some extent relevant to the Counsel for the Relatives, and the Counsel for the Relatives have responded that they will give their answer in early September 2020. The prosecution has said they will not be able to respond to the questions until they have heard from the Counsel for the Relatives. I'll now move on towards the end of my introductory statement. As was said, Mr. Pulatov's defense will first get the opportunity to speak. After that, the prosecution will give us a presentation of its investigations. If it does not come up during the prosecution's presentation, the court would like to be informed regarding the current situation in the investigation,
naar de betrokkenheid van andere personen
into
van de
the
verdachten die
possible,
zelfs worden vervolgd.
possible involvement of other people in addition
En
to
tevens
today's suspects. In addition,
de rechtbank
the court would like to
die het
hear,
Openbaar
if the
Ministerie
prosecution
daarop kan en
wishes,
wil ingaan, graag een reactie van het
the
Openbaar
court would like
Ministerie
to hear the
naar aanleiding
prosecution's
van
response
berichten
regarding
dat de verdachte
reports
Tjatchenko zou zijn
that
aangehouden.
suspect Karchenko has been arrested in Ukraine,
En over het recente interview
and a recent
van
interview
de heer Girkin
with Mr.
in
Girkin,
de openbaarheid is gekomen.
which has been made public.
En, zoals ik net al zei, voor zover
As I said a moment ago,
plaatsgevonden met het rechtsbijstandteam,
if they have been in talks with the Council for the Relatives, the court would like to be informed of the outcome of their discussions. First, however, I give Mr. Pulatov's defense the floor.
dank u wel. Okay. Ik heb u niet net eerder gevraagd, maar
The presiding
neem aan
judge,
dat ook voor
I did ask you
voorzien in
earlier
een
on,
exemplaar voor de
but
tolken.
I assume you also have a copy for the interpreters. Yes, says the defense.
Dank u wel, meneer de voorzitter
Thank you.
van de rechtbank.
Your Honours,
En overige aanwezigen.
Public Prosecution Service,
Een gedeelte van
other
wat
people
ik zal
present,
zeggen heb
part
ik
of what
al
I shall say
voorgehouden,
today
waar
has
mogelijk
already been
dubbelingen
covered by you.
voorkomen.
I'll try to avoid any
Want u heeft al
overlaps,
gezegd
because you have
dat wij
already
voorafgaand
pointed
aan
out
de
that
vorige
prior
zitting
to
kenbaar hadden
the
gemaakt
previous hearing,
dat wij
we
tijd
had
nodig
indicated that we needed
hadden
time
preliminaire verweren te onderzoeken of we die wilden voeren om te
to
onderzoeken
study
of
the
wij
possibility of putting
onderzoekswensen wilden
forward
indienen en dat
preliminary
u die tijd
objections,
aan
whether
ons
we
hebt
wanted to
gegeven.
formulate any request for
Aanvankelijk,
investigation, and you gave us
was
the
het
time to do
duidelijk
so. Initially,
dat
it
tot
was
met
clear to
vandaag,
us that up to
8
today,
juni, de dag
June
dat dit
8th,
tweede zittingsblok
the
aanvangt,
day in which we would
dat de
start
tijd er was
the second block
om
of
eventueel
hearings, that
preliminaire
there was
verweren
time
te voeren
to possibly put
en
forward
onderzoekswensen
preliminary
die
objections
gedurende dit
and to
zittingsblok zouden
put
worden opgegeven, dat die zouden worden getoetst op een manier
and
die neerkomt
to
op een
make
toetsing
sure
aan het
that
verdedigingsbesluit.
requests for investigations would be assessed in a way that boils down to an assessment of
Wij
the
waren ons
interest
ervan
of
bewust,
defense. We
ook
were
toen,
quite aware
dat
at
het
the time
natuurlijk
as
een
well
illusie is om te
that
denken
it's
dat wij met
obviously
z'n
an
tweeën,
illusion to think that
zelfs
the
met
two of
ondersteuning
us,
van
even with the
kantoorgenoten,
support of our
in een
associates,
maand of 3,
in about
4
3-4
een
months,
achterstand zouden
we
kunnen
would be
inhalen
able
van
to
6 jaar
catch up
onderzoek door het JIT,
6 years
waarbij
investigation
honderden
on the
opsporingsambtenaren,
part of the JIT, in
getuigen
which
en deskundigen
hundreds
uit meerdere
of
landen
investigating
betrokken zijn geweest
officers
en wat heeft
were
geresulteerd in
involved,
inmiddels
as
meer dan
well as
40.000
witnesses and
pagina's
experts from
dossier.
several countries.
En nog veel
And this led
omvangrijker
to what is more than
onderzoeksdossier,
40,000
waarbij een
pages
procesdossier
case
is
file,
gevoegd
and
in
also
meerdere
an
talen,
investigative
Nederlands, Engels, Russisch.
file that has not been added to the case
Dat neemt
file
niet weg
in
dat wij ons
English,
best hebben
Dutch and
gedaan
Russian.
om ons zoveel
Nonetheless,
mogelijk
we
in
have
te
done our
lezen.
best to
En ik heb
study
me
the file
afgevraagd,
as
hoe kun
much
je
as
nou
possible.
bepalen wat je
And
van ons
I've
kan
been wondering,
verwachten?
how can you really decide how much you
Je
can
kunt
expect
kijken,
from us?
daar heb ik bijvoorbeeld naar
You could,
gekeken,
for
naar de
instance,
globale
and we did so,
studienorm
you could look at
voor een
the
student op academisch niveau.
general standard,
Al
global
naar gelang de
study
complexiteit van
standard
wat
for
wordt
an
bestudeerd,
average university
wordt
student.
verwacht dat 5
Depending on
tot
the
10
complexity of
pagina's
what
per
needs to
uur
be
aan
studied,
wetenschappelijke
it has been
literatuur worden
established that one can
bestudeerd.
expect that a student
Ter
can study
illustratie, als je
5
van
to
die
10
norm zou
pages
uitgaan
scientific
en als je aan de
literature.
bovengrens zou gaan
Now,
zitten,
if we would take this standard and if
als
we
wij
would
verder
look at the
niets
upper
anders zouden
limit,
hebben gedaan
and
de
if we would have
afgelopen
done nothing
maanden
else over
dan
the
een
past
dossier
few
lezen,
months, nothing else
dan
than
zouden wij
read
nu
the case
op zo'n
file,
3000
then now
pagina's per persoon
we
zitten.
would have to have read 3,000
Je mag van ons
pages
natuurlijk
per
meer
person.
verwachten
Obviously,
dan een
one can
universiteit
expect
van
more
haar
from
studenten
us
verwacht.
than one can expect from a
Maar niet meer dan het
university
tienvoudige.
student, but
En
not
dat is
more
waar
than
we studeren.
tenfold. this amount. And that's what it means, studying a case file of 40,000 pages. That's what that means. And furthermore, this case file is not only sizable, but reading the file is very time-consuming, also for a number of other reasons. I shall explain. First of all, the complexity of this file. It is complex subject matter, and for some subject matters, legal knowledge alone is insufficient. Sometimes you need, I shall call it, technical expertise. Legal expertise is quite different from scientific knowledge of, for instance, impact traces on an aircraft, and the question as to which ammunition particles came from which weapon, and how primary and secondary radar systems work, and why it is plausible, or isn't plausible, that at specific crucial points in time these radar systems were not operational, and whether or not a smoke trace must have been caused by a specific type of missile. And it's quite common to involve external specialists in these cases, but that's time-consuming. Now, the file. First of all we have is a digital file. We read this digital file, and in consultation with the public prosecution and upon request of the public prosecution, we are reading this digital file from 2 standalone laptops, so that the substance of the file is not accessible from the internet, and this is for safety reasons, security reasons, particularly data security. And it has its advantages, but it also has major disadvantages. First of all, we experience that it is practically impossible for us to have an overview or a grip on such a sizable file with a layered structure of sometimes clicking on through hyperlinks, clicking onto other files. It's wonderful that we have this technology and that you can click in one document, that you can move on to the next file, and in that document you will possibly find a reference to dozens of other files, so you can click on and on and on. But sometimes you have to open 10 documents at the same time. You have to have them open on your desktop in order to have an overview and to have a complete view of what's going on. Furthermore, with just 2 laptops, that means that only 2 people can take cognizance of the file at the same time. After having been refused our reasoned requests to the public prosecution office to get a paper file, the court has, in the meantime, granted us this request. Thank you for that. But this is time-consuming, and we do not have this paper file yet, and so we've had to deal with the restrictions and limitations of having a digital file. Furthermore, with respect to the structure of the file, reading and understanding, in this case, is very time-consuming, because indexes with the incorporated, in other words, the relevant documents, are referred to per subtopic are not complete, and documents with an explanation with regard to the chronology and the structure of the preliminary inquiry are lacking. In other large or complex criminal investigations, usually you have official records in which you can find which investigative measures have been carried out, when they were carried out, and which documents have been incorporated in the case file per subtopic. And with these chronological overviews, the defense can check when and if certain investigative measures have taken place, and can check whether the defense has been able to take cognizance of all the documents that are relevant. Referring to Section 2 and 3 of the order regarding documents of the proceedings in criminal cases, we requested the public prosecution service, by means of a letter of March 17 and April 24, 2020, to provide us with these indexes and a chronological account. Public prosecution has informed us that they will not grant us these requests because they say that this file would be sufficient. We disagree with that, and we'll be discussing that at a later point in time, but it is relevant because we've experienced that reading the file without having these accounts and these indexes is very time-consuming and has delayed matters for us. And as far as the time that we needed to read the file, Less than 2 weeks ago, on 26 May 2020, we received the third set of documents in addition to the file, consisting of 1,300 pages and 48 corrections to pages that had been provided earlier. And obviously, this once again is time-consuming to study this. In short, as I said, it is an illusion to think that a couple of months would suffice to catch up with respect to the public prosecution. Nonetheless, on March 9, 2020, a period of 3 months seemed to be sufficient in order to determine whether or not we wanted to put forward preliminary objections and also to be able to put forward part of our requests concerning the investigation. March 9, 2020, we could not have predicted how the world would change. On the first hearing day on March 9, 2020, our Prime Minister, Mr. Rutte, announced that shaking hands would, for the time being, be a thing of the past. At the time, he was not the only one who thought this was somewhat funny. The seriousness of corona and the impact of the measures became very clear. On March 12, 2020, the first measures were taken in the context of what we now know as an intelligent lockdown. On March 15, 2020, the schools were closed, and on March 19, 2020, the Netherlands closed its borders for people from outside Europe. And outside Europe, there were also harsh measures with respect to the corona. Initially, the situation didn't seem to be so severe in Russia, but at late March 2020, Russia closed its borders. And since April 2020, there is a strict lockdown applicable, and no one can travel into the country. According to the Dutch Ministry of Foreign Affairs, the Russian borders are closed and no regular international air traffic is allowed from and to Russian airports. And although the measures in the Netherlands are being relaxed gradually, so far that has not been the case in Russia. On May 27, 2020, it was announced that Moscow, and this is the Dutch news outlet that says that Moscow would remain in lockdown for a longer period of time. The lockdown has been extended at least until June 14, 2020. All these measures have an enormous impact on the defense of Mr. Pulatov and the preparation of such defense. On March 9, 2020, we planned to study the file first and then spend about 2 weeks in Russia in order to discuss the substance of the file with our client, in order to tell him what the substance of the file was and ask him for input, and to discuss possible requests for investigation, what kind of defense we could pursue and what the impact of such a defense could be. We had planned to take the time to do that, to take him through it and to fine-tune matters. But over the past few months, it became clear that it would be impossible to carry out this plan. We sometimes ask the question, also by the Public Prosecution Service, whether our contact with the client, given the fact that we can't see him in person now, whether this contact could not take place in a different way, such as by telephone or internet. We were quite surprised that the prosecution would even ask us this question, because if we look at what the public prosecution put forward in the first hearing block on March 9, 2020, and the media's headlines said, after this statement of the public prosecution, the public prosecution is highly condemnatory of Russia. Russia is trying to interfere with the fact-finding MH17. Threat from Russia vis-à-vis the MH17 proceedings is a realistic scenario. And feeding these headlines is the explanation on the state of play of the investigation. And the public prosecution referred to a cynical disinformation campaign on the fate of flight MH17 and referred to a government. It hadn't been specified which government, but it's clear to everybody which government was meant. A government would be involved, according to the prosecution service. According to the prosecution service, we have to take into account that there will be attempts of cyber operations and hacking on the part of the GRU. I'm quoting, "There are strong indications that it's very important to the Russian government to obstruct this investigation. It doesn't shy away from using the security services. And the security services have capacity to intercept communication," according to the prosecution service. On the one hand, the prosecution service is convinced that from or on behalf of Russia, attempts would be made to interfere with, threaten, or even worse, the proceedings with respect to MH17. The defense, on the other hand, would have to simply accept that its communication should be done via digital channels with its client. This doesn't tally. However, the question as to whether we cannot communicate remotely with our client is quite an understandable question to be asked by an outsider. But communicating remotely is not a possibility. Quite apart from what I just said, also in other cases, such conversations do not take place over the phone, over the internet. We simply cannot know, and we cannot guarantee that nobody's listening into us, our conversations. And plus, in this case, even prior to the corona measures, we only we didn't have any other kind of contact with our client. Prior to the corona limitations, practically it was impossible to have any other contact with our client. Quite apart from the question whether it is practical or safe to communicate remotely or whether it's desirable to do so, as far as we're concerned, it's undesirable to do so. And in view of this, the fact that it's undesirable to do so, I would like to say the following. In the light of the lockdown and corona, obviously we're quite prepared to see and explore whether there's something we can do, whether we can do more than we would do otherwise, and whether communication could take place in some other way. This may not be our preference, but sometimes, that's just the way things work. Because of these measures, we all have to give in a bit. But as to this question, as to whether during the lockdown we could communicate with our client in some other ways, this is a question that we reflected on. I shall explain why the answer to this question, nonetheless, is no. First of all, Oleg Pulatov speaks Russian. We don't. We speak Dutch, we speak English, but he doesn't. And as a consequence, every sentence that we say to each other first will have to be translated from Dutch or English into Russian by an interpreter. The response then will have to be translated from Russian into Dutch or English, etc., back and forth. And that is also the case if you speak with someone in person. Obviously, you will also have the linguistic problem. The interpreter will also have to translate. But it's less time-consuming and it's much more understandable if you're sitting in the same room, if you have to communicate with an interpreter, because then you can also depend on facial expressions, tone of voice. You can show images, you can indicate things, you can play audio recordings. Communicating through an interpreter without being in the same room can be an option if short and not too complicated questions need to be discussed. But these are not the questions that we need to ask in this case. These are not the questions that need to be discussed. Tens of thousands of pages with sensitive and complicated subject matters need to be discussed. And it's absolutely impossible to discuss a file, such a sizable file, over the phone or over the internet with an interpreter. That would be very time-consuming, would cost a lot of money. But moreover, and I think this is even the most important element, that crucial details and nuances may be lost in translation. One cannot determine or hardly determine whether the information is being understood by the other party. I would like to highlight that Ms. Kutina, the Russian lawyer who attended the hearing last time, even if she would have a file, which is not the case, and even if she would be able to replace us, which is not possible either, because formally she's not a party to the proceedings and she doesn't have to prepare the defense, Ms. Kutina only speaks a couple of words of English. In order to limit the delays caused by the linguistic problems, on the 24th of April 2020, we requested that the case file be translated into Russian. Just to be clear, the client cannot take cognizance of his own case file, that with the exception of some translated sections, some intercepted telephone conversations that are in Russian, But most of it is in Dutch or in English, and by means of a translated version, client would have had the opportunity to study the case file. That possibly could have saved time. And that way, once we are able to have a personal contact with him, he would have taken cognizance of the substance of the case, and we wouldn't have to explain everything. And that, in theory, would be beneficial, or could have been beneficial, to the preparation of our defense. This request has been denied, and during this hearing block, we will be coming back to this matter. Second, besides the linguistic problem, this impossibility to communicate remotely, and in light of the size, complexity, and sensitivity of the case file, there's another element: the importance of trust, and the relationship of trust between client and counsel. And this relationship of trust between client and counsel is indispensable, and that applies in every case, but particularly in this case, a case that concerns a disaster of an enormous magnitude. Our client is a Russian suspect located in Russia, and he needs to be defended by lawyers registered in the Netherlands. A Russian accused person that hardly knows his counsel, and counsel that comes from the country that suspects him and prosecutes him, amongst other things, for the murder of 298 people, of which, a country of which he hears regularly that this country is involved in spreading disinformation, just as we keep hearing information about Russia. You can well imagine that such a relationship of trust needs to grow, and we intended to invest in that, amongst other things, as I just explained, by traveling to Russia and spending about 2 weeks there in order to discuss the case file with him and the defense. And without such investments in time, it's in fact impossible to build such a relationship of trust. And in line with that, it is impossible to acquire enough knowledge in order to be able to take certain decisions. Since the previous hearing, and still, it is impossible to have anything more than very superficial contact through intermediaries with our client. Something else that is also impossible is contact with these non-legal specialists, these experts that I was referring to earlier on, in order to be able to determine, with respect to certain subjects, and I'm particularly referring to investigations that require specific non-legal knowledge, in order to be able to determine which questions we would like to ask, which investigation we would consider to be desirable, and which experts we would like to interview. For that, we need to consult with, and we require the advice and recommendations of specialists on these subjects. And these specialists very often do not live in the Netherlands. And also, as a consequence of the corona measures, we cannot have good contact with these people, and we cannot involve them in this case. In short, the information that we have at this point is incomplete, because all we can do is take cognizance of the digital case file. We can't do anything more, and we cannot get input from our client and specific specialists and experts, and we cannot, or we can hardly give any information to our client. And because of these restrictions, given the impossibility to exchange information, we cannot take certain positions and certain decisions, because of the lack of the required authorization of our client, cannot be taken. And that has certain implications.
The fact that I'm raising this and that I'm also explaining it, and the impediments we are facing when preparing defense, must, although it may seem so, not be seen as a request for compassion with defense. That is not what we intend. The reason why we state this and explain the impediments we face and the difficulties we face is a legal reason. The facts, against the background of that what is required in view of proper defense, has a consequence for the manner in which our requests will be assessed by your court. The court will have to decide each time whether the request for investigation we've asked must be allowed. Requests for investigations that have been raised at least 10 days before the hearing will be awarded if they are in the intention of the defense. After that time, they will be assessed by means of the question whether they are necessary. So that's a more strict test. But the term of 10 days before the hearing is not reasonable in all cases. So, as the Supreme Court in the Netherlands decided, the necessity criterion must be explained in circumstances in a manner that it is not substantially different from what would be achieved when it would be tested on behalf of the interest of the defense. The term of 10 days before the hearing ended by the end of February 2020. Your court has, as you've already stated, on the 23rd of March 2020 decided that requests for investigation that were listed during this block of hearings will be assessed by means of the necessity criterion, but in a manner that is not substantially different when you would apply the interest of the defense. In the letter of the 12th of May, your chair has expressed that we need not state all of the investigating requests, but that we will have to substantiate why we cannot, so that these would not be assessed only on the necessity at a later time. The circumstances that I've described above must, in the perspective of the defense, lead to the fact that also requests for investigation that we would raise after this block of hearings, in particular after we have been able to read the file fully and after having discussed it with our client and experts, that also those requests for investigation must be assessed in such a manner, which I mean not just pertaining to the necessity, but in a manner that would mean that it is tested against the interest of the defense. That is the reason why we've explained these circumstances and raised them. In a next stage, when we will raise the request for investigation that we cannot raise now, in those circumstances we will call for this assessment. And as you can derive from what I've already stated, we would rather have much more time and opportunities to prepare. And we would like to put the proceedings on hold in the meantime and definitely during the corona limitations, as has happened in many other cases, and to continue afterwards, after we have had the opportunity to read everything, and after we had discussed with our client his vision and the decision to be taken, because it's not our defense, it's his defense. In the letters of the 24th of April and the 8th of May, we have informed the court and the Public Prosecution Service about our concerns on the case file with regard to corona and the consequences for our preparation. As stated, we've asked the Public Prosecution Service for more clarity to provide indexes and reports, and we have announced that we cannot able to be in brief able to prepare the block of hearings of the 8th of June as we would have wanted to. Your chair has stated that preliminary defenses can be raised on the 8th of June, and otherwise it will be defenses that we can raise in arguments later. Now, we will not be able to raise all of the requests for investigation and what the consequences will be. Now that it is clear that the longer interruption that we would want cannot be allowed, we have investigated what we can do in spite of the present circumstances and restrictions. We've tried not to be reluctant. We have made an effort to do the best of our ability to do what we can be expected to do. I will explain to you what difficult decisions we had to make. First of all, what we cannot do now is present preliminary defenses. The preliminary defense that we have considered to present will be explained briefly, also because it can be raised at a later time. That defense pertains to the fact whether the Netherlands have jurisdiction and, in extension thereof, whether the Dutch prosecution service has a right to prosecute and therefore is admissible. Because the disaster with MH17 did not take place in the Netherlands but in the Ukraine, so you can wonder whether the Dutch PPS is the right body to prosecute. Now, if the question would be answered in the affirmative, the question is whether that jurisdiction should not be restricted because the disaster took place on a location in the Ukraine where a war situation was ongoing. The Dutch Code of Criminal Procedure decides that the jurisdiction of the Netherlands may be limited because of the exceptions acknowledged in international law. One of these exceptions in international law can be found in Article 43 of the second paragraph of the additional protocol to the Geneva Convention to which Russia and the Ukraine are party. The text reads, "The armed forces of a party to a conflict are combatants." And that is to say, they have the right to participate directly in hostilities. I left out part of the quote, which are details that pertain to the conditions when you can be combatant. But what is important now is that combatants are entitled to participate in hostilities and armed conflict. That doesn't mean that anything they do is lawful. It definitely doesn't mean that they may shoot down a civil aircraft intentionally. But it does mean that when a person meets the conditions to participate in an armed conflict, that there's a guarantee in it that in principle he cannot be held criminally liable for the war operations. That is what is called combatant immunity. I said in principle, because based on international common law, it is assumed that this exclusion of criminal law liability does not apply when combatants commit war crimes. And therefore, the condition is that a person can indeed be designated as a member of the armed forces of one of the parties that is party to such an international armed conflict. Article 4 of the Third Geneva Convention stipulates what conditions must be met before a person can be qualified in this status. This status of combatant is only applied to members of the official armed forces of one of the parties, but can also be awarded to members of other parties to the conflict, such as militias and resistance groups. The process file has partial files that pertain to such questions. The public prosecution has referred to these files in its letter of the 11th July 2019, even before we were engaged in the case, that in explanation of the present analysis of combatant immunity would lead to some conclusion and a preliminary assessment by the public prosecution. So the public prosecution believes that irrespective of the nature of the conflict, these suspects cannot claim the combatant status. And there are two positions of the public prosecution that are the basis of this conclusion, which is that the accused and the Russian Federation would have denied that they participated in the conflict based on behalf of the Russian Federation, and the separatists, which the accused would not be subject to an effective international disciplinary system which imposed compliance with international humanitarian law, but they could indeed commit systematically serious war crimes without any response, as stated by the public prosecution in July 2019. Back to the 8th of June 2020. As stated, invocation of combatant immunity may lead to inadmissibility. Now, the question is raised before the evidentiary issues. If it is true, it would mean an end of the Dutch prosecution of Oleg Pulatov, and if it is true, the evidentiary issues will not be discussed. For that reason, the defense of inadmissibility is a defense that can be presented before the discussion of the case on substance, or rather preliminary, if you would indeed argue that defense. In view of that opportunity, we intended to investigate whether such preliminary defense could be presented. Now, although the public prosecution means that they are very clear on this topic, it is much too unclear for us to be able to take a position, which means there are issues with regard to the interpretation of the conflict in the east of the Ukraine and the people that were combating in that respect. In particular, to what extent was it an international armed conflict? Must these armed forces be considered to be combatants within the meaning of the Geneva Conventions? To what extent did they act in accordance with the conditions set to that, but also for other aspects that are important to assess such an invocation of combatant immunity? The investigation of the Public Prosecution Service is nearly exclusively based on public sources and therefore not far-fetching enough. There are many relevant issues to be raised with regard to the specific role and knowledge of the alleged involved persons, in particular but not exclusively, the role and the knowledge of our client in that respect, such as who did exactly what, who was part of which armed forces, who knew what and what did they think they knew and why, and who determined what, etc. This lack of clarity in these questions must first be discussed with our client before we can do anything in this respect, and they must be investigated further. Now, such consultations about issues as these is, as we've explained, impossible at present. Without having his input about the facts that may be relevant for such a defense, and without consultation with him about the question whether it is desirable to present such defense and what the consequences will be, we cannot continue. In particular, we cannot determine whether further investigation would be in the interest of the defense. Now, all of this led to the fact that we've decided not to present the combatant immunity defense right now, and also not to list any request for investigation now in that respect. However, we do not exclude explicitly, but we cannot determine yet whether we may raise requests for investigation later and whether we may present this defense later. However, we are unable to do so now. What we cannot do either at present is raise questions or list investigation requests that pertain to matters that may affect exculpatory or incriminating evidence of the involvement of our client or participation. This consists of more than the matter who can be considered to be a participant or a perpetrator of the charges. This also pertains to questions that relate to, for instance, underlying higher or even lower, more or less direct involvement in the charges and or the disaster in a wider sense. It also concerns, in other words, about the issues in a wide perspective with regard to alleged involvement in acts and or decisions that may have led to the disaster directly or indirectly, or possibly. And the answers to those questions may lead to questions about other topics. And I will give you two examples. And based on that, I will explain why we cannot continue. The file contains sound fragments that are allocated to various persons, including our clients. And these are, most of them are in Russian. There are translations in there, but most of them are in Russian. Such recordings we would like to listen to, together with our client, to hear his response, to investigate whether it is his voice, or if it's not his voice, if he knows whose voice it is. to listen to what would be extra on the tape, but not in the file. In what context that conversation took place, if my client would have been involved, to investigate what may have been meant with the choice of words, or whether this choice of words would have another meaning for military strategic reasons, for instance. The answers that we do not yet know about these questions may lead to other questions and or requests for investigations, for instance, requests that may be of interest to assess whether the translation of these type of conversations was correct, whether the material can be manipulated, etc. Without being able to talk to our client in a constructive manner, it is impossible to raise such questions and phrase these requests for investigation. Another example with regard to the statements of witnesses pertaining to the alleged involvement of persons, whether or not identified, that would have contributed to the disaster with flight MH17. We must be able to discuss with his client what is his perspective on such interviews and the substance thereof before we can decide whether we have questions and whether we wish to interview the witness too. Without his input and his consent, we cannot ask questions about such topics and other topics, and we cannot list investigative requests. Not just the lack of contact with our client, but also the lack of contact with specialists, with experts, does hamper us in asking questions about some topics. It is, for instance, about topics that are related to that will be stated by us on the 22nd of June as far as possible. But there are other reasons too, such as the lack of contact with experts and, in some cases, also simple lack of time. What we can do is raise questions and present requests for investigation on some other topics in as far as we can, and we will do so in accordance with the agenda that the chair has adopted in the week of the 22nd of June, as we expect, after the Public Prosecution Service has given an explanation of and provided insight in the various investigative actions and the manner in which the file was structured. In that week, we will raise as many questions as we can and state the request for investigation. However, this does not affect the restrictions I've mentioned before, also with regard to the topics on which we will be able to raise questions. These restrictions still apply, so therefore our requests will not be complete even for these topics. You can derive from the time we've requested to speak that we will indeed mention a number of topics and will not be reluctant in doing so. For completeness sake, I state that with regard to all the topics, also the partial topics, but any other topics, that we do retain the right to ask further questions at a later time, for instance, to the PPS, through the court, and to list any requests for investigation. Thank you for your attention. Thank you.
Okay, looking at the timetable, which I proposed earlier, after hearing the introductory comments and the defense, I think we would now say that we don't want to respond immediately. You have made a statement. And on the basis of previous communications, we heard that we would be hearing a presentation, and that after the presentation and after an adjournment, you would like to come back and go further into your investigation requests. You'd have something to say at that point. Yes, that's a good summary. Okay, in that case then, we could now make a start on the presentation from the prosecution, but I'm just looking at the clock. It's 11:30. Yes. Now, the preparation of defense in Mr. Pilatov's case was a very substantial point that has been raised. There's a number of questions we'd like to ask on that. There's a number of issues that we really like to have fully clarified. I think we'd like to do that before we move on to have the presentation of the investigation. As far as we're concerned, we'd like to do that before noon. Okay, if you have a number of questions, yes, I think there's no problem with you asking them. If that can shed light on things, go ahead, please, prosecutor. As I said, President, this is a very substantive point in defense, the preparation of defense in the Pulatov case. We've paid due attention to what the defense has been saying and the limitations they faced. But what's not entirely clear to us is whether I've understood correctly that from the time that travel restrictions were imposed, that they've had no contact at all. No contact at all between Council and Mr. Pulatov. Is it the case that no contact has taken place at all since that time? That's my first question. I could have an answer now, or I can carry on. Yes, I think it would be better if you could ask all your questions, and then we'll see whether we can answer them all immediately. Well, if you can give an answer straight away, then that would be easier. No, please go on to your next question. Okay, that was my first question. Another question, if I understand correctly. Mr. Pulatov does not feel that he is free to communicate with his counsel other than personally. And I understand from your submissions that partly that is because he has no confidence that he's not being listened in on, his communications are not being intercepted by the Dutch authorities. And I hardly need to tell you this as Dutch lawyers, but in the Netherlands, contact between lawyers and suspects are guaranteed confidential. The phone lines are protected. So, regarding your client's misgivings here, the question is whether his suspicions are justified and to what extent we should take account of them. That's the question in the prosecution's mind. Another point is you referred to what we said on the 10th of March regarding the safety of witnesses and the risks that you say they might face. On the 10th of March, just to clarify things, we explained that the risks facing witnesses were dependent on where the witness lives and whether the witness statement chimes in with what a particular armed group or government says regarding the area where the witness lives. We gave an example, I quote, a witness who says that Ukraine was behind the MH17 attack has nothing to fear, very little to fear in Russia. At this point, we have no reason to suspect that your client, Mr. Pulatov, is facing any dangers at present. As far as we can ascertain, his interests are in line with those of the Russian Federation. If that were to change, if the situation were to become different, if he then had justified fear that he might be being hacked or intercepted by the Russian authorities in his confidential talks with his Dutch lawyers, then that, I think, is something which we would have been informed of by defense at an early stage. And we'd have to discuss such misgivings in camera. Now, nothing so specific has been said at this point, but I just wanted to flag that issue up. And the question is there a need for further in-camera discussions on this matter? In addition, you intimated that your client has not yet been in a position to read documents in the file. Now, at an earlier stage, Russian translations have been made available. These are summaries of the file. 174 pages. We've provided Russian translation of Mr. Pulatov's personal file, just more than 60 pages. Our question is whether Mr. Pulatov has already read those papers. Finally, just looking to my colleague, but for me there's one remaining question, my last question. How do you see planning into the future now? We understand we're dealing with restrictions, but we're looking at what's possible. That's a valuable thing to do. The question is how you see the further development of Mr. Pulatov's defense going, and how much time you think will be required. Because if I understand you correctly, any further requests for investigation would arise from personal contact with your client and personal discussion of the entire file with him, with an interpreter. That's what I understood to be the case. If I've misunderstood, then do please let me know. But if we look at what you were saying, well, I want to be careful. I can see you shaking your head, madam. I can see you shaking your head. Now, I would appreciate it if you would clarify this. I may have misunderstood. How do you see further discussions of the case and preparation of further requests for investigation taking place? How much time do you think you will need? Now, if we imagine a situation where travel restrictions would be lifted in the near future, how much time do you think you would then require? And that's quite separate from the question of how an effective defense in the Pulatov case would actually shape up. There could be different opinions on that, but it's important for the prosecution to have a clear idea of this, because the other cases are also running. The cases where, as far as the prosecution is concerned, no further investigation is required, and so we can move on to the merits of the case. And we need to adopt a position in those cases regarding whether they should continue to carry on simultaneously with Mr. Pulatov's case or not. That was your questions then? Yes, I'll wait for the replies. I think that might be better than asking further questions at this point. We'll see whether there are any questions after we've heard the replies. Yes, I can give a couple of replies immediately, and others I'll come back to later. First question. It's not clear whether we've had any contact with our client since the travel restrictions. What I said a moment ago, and I'll be happy to repeat it, is that since the travel restrictions were imposed, we've only been able to have very superficial contact via intermediaries. Ms. Kutina has been an example of that. That's what I said earlier. Clearly, I didn't make myself clear, so I think no problem repeating that. The second point or question really, from prosecution is whether our client feels free to communicate with us other than face-to-face, and what the framework is, and whether it isn't safe, and if it isn't safe, then what other plans or agreements could be reached. Well, to make it absolutely clear, it's not so much the question of whether it is safe or not. The question is building trust. If the prosecution is now asking us, well, basically what they're saying is if Pulatov wants to say something which is different from what the Russian state has been saying so far, do let us know. Well, we haven't got to that stage yet. What I've tried to explain is that contact has not been possible. Before you can have meaningful contact, before you can really talk things over, particularly very complex and very sensitive issues, you've got to build a relationship first, and we can't do that. It's not the case that you just phone someone up and say, how are things going? It's not how these things work. So it is quite possible that you believe you know where there might be genuine dangers and not, but that's not the point. It's not the point of what dangers are actually out there. It's the point of how you can deal with a client, and if someone believes that he's in danger. So we haven't reached that stage yet. That's the main reason for the explanatory points that I made. It's not in order to reach new agreements with the prosecution and discuss a number of issues behind closed doors. That's absolutely not what is required at this stage. The third question from prosecution was whether Pulatov has read the documents. I don't know. Of course, the prosecution mentioned that we had said that we're not aware of any translated files. Well, no, what I said was that there were partial translations. Not everything has been translated. And indeed, there was the 174 pages and the 60 pages, that's the summary and the personal file. But when I talk about the untranslated parts, 39,000 odd pages have not been translated. So he certainly hasn't been able to read those. Then scheduling into the future. Well, if the prosecution has the impression that we absolutely cannot proceed, then the prosecution has got the wrong end of the stick. We're saying what we would like to do, we would like to see documents and tell you how things are currently going. And the President summed this up well. After we've heard from prosecution in the coming days, and after we've had time to consider our defence better, at that point we will be able to submit as many investigation requests and questions as possible. We don't know what might arise at a later stage. And that is why I think it makes sense for at least that question to be responded to afterwards. Maybe all the other questions as well. We'd come back to you on that after we've heard the opposition presentation. I think we need a cloth here. Perhaps we could courteously ask the usher to do that. We need to clean the microphone. Right. Well, President, there are a couple of questions I'd like to ask, and I'd like to say why I don't think we can wait until we proceed again on the 22nd of June. And it's because of the planning of the hearings and the substance of the case. Now, the prosecution has already said that we think it is important to look well into the future at this hearing, well into the future, and plan thoroughly for the future timetabling, because it's the only way of making sure that this case can be dealt with within reasonable time. You can't keep on saying, oh, let's wait a bit longer, let's wait a bit longer, and let us speak later. Now, after my colleague asked a question, as I see it, the defense did not answer the main question, the most important question regarding what faces us. In paragraph 38 of the presentation, we're told that since the previous hearing, it has been impossible for us to have any contact other than very superficial contact with our client via an intermediary. That is stated from the defence's point of view, not Mr. Pulatov's point of view. But the only person who has rights involved here is Mr. Pulatov, not the defense counsel. If Mr. Pulatov chooses not to have any contact other than superficially via an intermediary with his own counsel, then that is a matter for Mr. Pulatov. It's his decision. If it's actually impossible to have contact with Mr. Pulatov, then we need to be told exactly what the impossibilities are. If the defense chooses not to give us this information, all the prosecution can assume is that Mr. Pulatov is choosing not to have meaningful contact with his counsel, although it is perfectly possible. Regarding the building up of trust, I think we have to assume that Mr. Pulatov's Dutch counsel were already introduced to Mr. Pulatov in the last quarter of 2019. So it's not the case that they've had absolutely no personal contact possibilities at all. Before the travel restrictions, they had had a couple of months to get to know each other. Then the specific question that I still have regards the specialists from a number of countries, which are listed in paragraph 40. If I understand correctly, the defense is saying we can only submit meaningful investigation requests and think of the substance of the case once we've had personal contact with Mr. Pulatov and once we've had personal contact with specialists in a number of countries, because of course that is difficult, well, it's impossible at the moment because of travel restrictions. Now, in order to schedule the work of this case, it's important for us to know which countries travel needs to be possible to. If you want to ask a specialist from Brazil, US, or a number of other countries, rather at long distance where we don't expect travel restrictions to be lifted very quickly, rather than some nearby European countries, that makes all the difference in the world. So on the basis of what's currently on the table, we have to say Mr. Pulatov has had Russian language translations of the most important parts of the file from his point of view, to a larger extent than is normal in cases of suspects who can't read Dutch. We don't know any reason why Mr. Pulatov would not read these documents and why he wouldn't then be able to get in touch with his counsel afterwards. And if there are genuine obstacles making it actually impossible, we could then discuss them in camera, because that's relevant, because it has an impact on the extent to which it is Mr. Pulatov's own choice to prevent his counsel submitting investigative requests, or whether it's not his own choice. So that's the second point then, is this point of specialists. At the moment, the defense could tell us all the things that it can't do, but if it doesn't tell us exactly what is impossible, we have no way of telling how long the difficulties will pertain, what difficulties might disappear in the near future, and that will have an impact on the prosecution to say when we would be talking about any further delays to this case, and in particular of whether the cases can all be dealt with simultaneously. So I think I would therefore invite defense to give us more specific information than is currently done. Otherwise, we'll just have to cope with the information that we've got and the conclusions that we are able to draw from that. Thank you. Does the defense wish to respond? Yes, well, I'd just be repeating myself. Briefly, the prosecution, well, I think really hasn't understood us. The last thing the prosecution said was the question of whether it was Mr. Pulatov's own choice not to submit any investigation requests at this hearing. That's absolutely not what I said. That is not what I said, that we're not going to submit any requests for investigation at these hearings. No, what I said is I said what we would have preferred to do, but if you listen, you heard me say that we will be submitting some investigation requests. Now, from the 22nd of June onwards, in that block, we will, as far as possible, submit investigation requests. And now you're asking for all kinds of specific details from us. But what I was saying a moment ago was explaining what we won't be doing. And specifically, the idea would be to discuss the matter after we've heard from the prosecution. I've said it's been difficult that because the presentation is not on file. That's part of the problem. Yes, I just need to interrupt you for a moment. It's quite possible there's a difficulty. I just wanted to find a good opportunity to interrupt you, but I think it was necessary to interrupt you at that point. In any case, just for a few minutes, I'm just wondering whether it might be an idea to have a break for a few minutes, or maybe we should actually have a break now and come back at 1. Yes, so perhaps, we'll adjourn now until 1 o'clock. Thank you.